Greetings. This is Miriam Stevens, and I will be discussing today as a requirement of one of my courses in my Master of Art from Public Relations, Legal and Ethics class, the 50th year anniversary, Sullivan versus the New York Times. It was a landmark case that altered how the press reports on government officials and libel interpretation. Again, my name is Miriam Stevens. I'm the CEO of MsStevensPR.com, the brand paramedic, and this is a requirement of my Public Relations Master of Arts degree. Let's give a little bit of history. March 9, 2014 was the 50th anniversary of a landmark case that changed the course of history regarding how the courts interpret First Amendment rights, freedom of speech, provability of libel and slander allegations, and the way media reports about government officials and their actions. Sullivan versus the New York Times sparked great controversy, deliberations, and ultimate favor for the press in a time where the backdrop in America was full of civil unrest. There were many in this era that spoke out against unfair practices, that raised the banner against discrimination, hatred, prejudice, and violence. This nonviolent protest became the object of heavy criticism with legal ramifications from one government official that viewed the New York Times political advertisement heed their rising voices as a direct attack on his leadership character and personal credibility. What we are going to do is explore several questions as it pertains to this landmark case and delve into the ethical implications that a public relations professional may incur when sharing information about a public official. First, let's look at the players in the case and present the factual tenets of the case, plaintiff versus defendant. The plaintiff, L.B. Sullivan, the defendants, the New York Times Company, and 4 local Alabama clergy. L.B. Sullivan. He was the plaintiff. He argued that his character had been misrepresented, defamed, and reputation harmed through libel. Now, he won initially in the lower courts, over half a million. After the appeal to the U.S. Supreme Court, the decision went in the favor of the defendants. Let's learn a little bit more about who was L.B. Sullivan. L.B. Sullivan was the person in charge with direct oversight supervision of the law enforcement agency in Montgomery, Alabama. According to encyclopedia.com, quote, L.B. Sullivan, the Montgomery City Commissioner responsible for supervising the city police department, filed a libel suit against 4 African-American clergymen and the New York Times in Alabama State Court. Sullivan alleged that the advertisement implicitly libeled him. Libel is a civil tort and consists of injuring someone's reputation by reporting falsehoods about that person. Who was L.B. Sullivan? He was the plaintiff in the case who brought suit against the New York Times and Alabama clergy, who he said misrepresented his character, defamed the police actions, and committed libel against him with the publication of the political piece. According to his testimony, L.B. Sullivan said he had direct oversight and responsibility of law enforcement in Montgomery. Quote, Commissioner of Public Affairs, and the duties are supervision of the police department, fire department, Department of Cemetery, and Department of Scales. End quote. L.B. Sullivan filed the libel suit against the defendant since he was the head of the police department, and the political advertisement suggested by accusation his support of enacting the quote-unquote wave of terror, police enforcement upon protesters and human rights activists. So what is libel? Libel constitutes communicating defamatory representation and statements against another where it is distributed in print. According to expertlaw.com, Quote, libel involves the making of defamatory statements in a printed or fixed media, such as a magazine or newspaper, end quote. If harm, misrepresentation, and egregiously flagrant press is distributed that alters the perception of another party, then this can be considered grounds for libel. Bottom line, if one ruins a person's reputation and good standing in the community, then they can end up in the court of law. Not only do lawsuits become tedious, inconvenience, the outcomes can become extremely costly if the defendant is accused of committing libel actions. To get further clarity on the elements comprising libel, expertlaw.com elaborates on what could become defamation and warrant an actionable lawsuit. Quote, typically, the elements of a cause of action for defamation include a false and defamatory statement concerning another, the unprivileged publication of the statement to a third party, that is, someone or somebody other than the person defamed by the statement. If the defamatory matter is of public concern, fault accounting at least to negligence on the part of the publisher and damage to the plaintiff. In the context of defamation law, a statement is published when it is made to the third party. End quote. Since L.B. Sullivan was the plaintiff, how did he have to prove libel? L.B. Sullivan had the burden to prove that the defendants in the case ruined his reputation, committed libel, caused him harm, defamed his character, and injury. He asserted that the article was malicious and inferred he was responsible for approving the wave of terror administered by police. Definition and elements that must be satisfied when proving a libel case are as follows. The plaintiff's burden of proof. The plaintiff in a libel action must prove all 6 essential elements to win a libel case. 1. Publication. 2. Identification. 3. Defamation. 4. Fault. 5. Falsity. And 6. Injury. And this is according to Carla K. Gower's Legal and Ethical Considerations for Public Relations booklet. Now, although never named, L.B. Sullivan still sued libel. A plaintiff, such as in the case of Sullivan versus New York Times, does not have to be specifically named in a publication if it is reasonable that the written information can only be about a certain person. Quote, a plaintiff can be defamed, however, without being explicitly named. If even one person in the community would recognize the person libeled, then there has been sufficient identification. Again, that's out of Gower's book. End quote. So, who were the defendants? The New York Times Company and 4 local Alabama clergy were the defendants in the lawsuit filed by L.B. Sullivan. And what was the motivating factor to create the political advertisement that sparked such a controversial outcry and court case by the plaintiff? Heed Their Rising Voice was a political advertisement created with a threefold agenda. First, to acquire funds for Martin Luther King Jr. legal defense. Second, to provide support for Southern students who were fighting for freedom. And third, to uplift the civil rights movement and win the freedom to vote. According to the actual Heed Their Rising Voice political advertisement, a fervent plea was announced as a call to action in hopes to elicit fellow Americans' support in the form of financial assistance. Quote, we urge you to join hands with our fellow Americans in the South by supporting with your dollars this combined appeal for all 3 needs: the defense of Martin Luther King, the support of the embattled students, and the struggles for the right to vote. What was the background motivation behind the political article that became the catalyst for the lawsuit? Again, Heed Their Rising Voice was a political advertisement created with just a threefold agenda. First, to acquire funds for Martin Luther King Jr.'s legal defense. Second, to provide support for Southern students who were fighting for freedom. And third, to uplift the civil rights movement and win the freedom to vote. So in the suit against the defendants, L.B. Sullivan's legal team pointed out several erroneous statements made in the political advertisement. The statements inferred that since L.B. Sullivan was the commissioner of police, he was the backbone behind the wave of terror enforcement against civil rights activists and protesters. Furthermore, the mention of students singing, quote, "My Country 'Tis of Thee," on the steps of the Alabama State Capitol was an error. The students actually sang a different song. The other inaccuracies were that the students were expelled from school when, in fact, they were expelled during a lunch counter sit-in. Finally, the significant exaggeration of the massive attendance of student body protests for expulsion was again a misnomer. These statements heightened the grievance that L.B. Sullivan had against the political advertisement. He claimed that because the information painted him and his regime in a negative light, it was libel. Answer.com provides additional clarity and insights on the false information that was presented in the political advertisement. Quote, "It was uncontroverted that several statements contained in the text of the advertisement were inaccurate. For example, the advertisement stated that students protesting racial segregation sang 'My Country 'Tis Thee' on the steps of the Alabama State Capitol, but they had actually sung the Star-Spangled Banner. It also said that several students were expelled from the school for leading that protest, but they were actually expelled for demanding service at a segregated lunch counter in the Montgomery County Courthouse on another day. Finally, the advertisement claimed that the entire student body of Alabama State College protested the expulsion, but only a majority of the students, not the entire student body, had protested the expulsion." End quote. So, what were the areas of contention that L.B. Sullivan brought in the libel suit? In Montgomery, Alabama, after students sang "My Country 'Tis of Thee" on the state capitol, that was false. They sang the Star-Spangled Banner. Their leaders were expelled from the school. That was false. They were expelled after a lunch counter sit-in. And truckloads of police armed with shotguns and tear gas ringed the Alabama State campus. Exaggeration. They did not ring the campus. When the entire student body protested, the state authorities, by refusing to re-register their dining hall, was padlocked in an attempt to starve them into submission. Again, all of this was false. L.B. Sullivan filed that libel suit against the defendants since he was the head of the police department, and the political advertisement suggested by accusation his support of enacting the wave of terror police enforcement upon protesters and human rights activists. Again, truckloads of police armed with shotguns and tear gas ringed the Alabama State campus. Again and again, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses. And now they have charged him with perjury, a felony under which they could imprison him for 10 years. Statements alleged to be of, and concerning L.B. Sullivan, the Montgomery, Alabama City Commissioner in charge of supervising the police department, they were all false. L.B. Sullivan initially wanted a retraction from the newspaper for the misinformation and bad light it depicted him as the head of the Montgomery police. When it didn't happen, a lawsuit occurred. L.B. Sullivan initially won his case in the lower Alabama courts and actually received a decision to be awarded $500,000 in damages. The defendants then sought an appeal through Alabama Appellate Court, but lost. Therefore, the United States Supreme Court became the final stop for this landmark case, and that was remarkably overturned in favor of the defendants. What was the main issue? Freedom of the press. Whether the First Amendment limits a state's power to award libel damage brought by a public official against critics of official public duties in a court. And that was from freedomforum.org. As we celebrate and reminisce on the ultimate decision to uphold the press freedom to conduct lively, uninhibited, and opinionated discussions in the media, this case remains the standard for how to proceed. Judge Brennan provided significant speech on why the decision was overturned by the lower courts and how the First Amendment should be upheld. The unanimous vote to rule in favor of the defendants by the Supreme Court and Judge Brennan's statement provide unequivocal logic behind the decision. Quote, the Supreme Court voted unanimously to overturn that verdict. The country's founders believed, Justice William Brennan Jr. wrote, quoting an earlier decision, that public discussion is a political duty and that this should be a fundamental privilege of the American government. Such discussion, he added, must be uninhibited, robust, and wide open, and may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials, end quote. Historical significance of the U.S. Supreme Court decision directly impacts my personal life, liberty, and pursuit of happiness as a legally voting citizen of the United States. I end with a powerful paragraph that indicates just how significant that a supported institution such as the New York Times was for promoting the cause of civil and human rights in the 1960s era. Not only has this case set the standard for upholding one's right to free speech in America, but it gives an awesome democratic blueprint for others across the world. So again, why was this a landmark case? Brennan spoke for the unanimous Supreme Court that overturned the jury's award. He wrote that debate on public issues should be uninhibited, robust, and wide open, that it may be well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. The key area in this decision was the intent and knowledge of producing maliciously false information. Unless that is definitively proven by the plaintiff, the courts will rule on the side of the defendant in a libel case. And before the Supreme Court decision, it was harder for someone to defend against being accused of committing libel. Since the decision, the press and other persons are afforded more leeway in sharing information and are protected by the Constitution. And finally, the right to debate, disagree, express opinions against public officials and government was supported by the highest court of the land. New York Times and the clergy, they were the defendants in this Sullivan's case against libel. According to Answers.com, the New York Times was the one of the major media vehicles and voice for the civil rights movement. Quote, New York Times cannot be fully understood without recognizing that it was driven not only by concerns about free expression, but also by the unique historical circumstances in which it arose. New York Times was, in short, a product of the civil rights movement of the 1950s and 60s. Like other devices designed to obstruct the civil rights movement, the libel judgment against the New York Times and the African American clergyman named in the advertisement was designed to dampen the drive for civil rights. After all, if this Alabama's jury's massive damage award could be sustained on the basis of such minor inaccuracies, then no person or institution would be free to challenge racial segregation in the South. New York Times, one of the most important decisions in the history of the First Amendment, was thus not only a triumph for free expression, it was a triumph for civil rights and racial equality as well. End of quote. So, what is my social media responsibility? Well, as a blogger, internet writer, social media enthusiast, I must be observant of my conduct. I need to be vigilant about the type of content that I produce to guard from factual errors and disparity of research. Although I can express opinions, I need to be cautious of any type of malicious, untrue perceptions and defamatory statements that I distribute, especially if I send it via the email. What is my professional impact? As a public relations professional, one must be astute to the legal and financial ramifications that can occur if any materials produced by that firm is found to be liable in court. The Supreme Court has afforded some liberties as it pertains to the burden of proof by a plaintiff. However, ethically, it is the ultimate responsibility of the public relations professional to know the laws that govern the media distribution of information in the state that business is being conducted. And what are social reflections that I have personally? I admire my predecessors who fought so that as an African American woman, I can have the freedom to advance in my life as a citizen with full rights to vote, choice to pursue higher education, and enjoyment to pursue personal happiness. I can respect the passion that went behind the text in the political advertisement because definitely in that day and age, the ability to have an internet voice to solicit much needed funding was not available. However, I still would want to portray a realistic and truthful picture in my writings so that no hint of deception could ever be associated with my work. It is my social obligation to abide by my personal convictions, faith, moral codes, and passion when delivering social stance in anything I subscribe to and endorse. The decision made by the Supreme Court Justice not only changed the course of how we conduct press and public relations in our society, but inspires others to pursue the same type of American liberties that we enjoy through our Constitution. It is our First Amendment protected right without restrictive costs as United States citizens to enjoy freedom of speech as individuals and media agents. Around the world, there are others still fighting to enjoy the liberties our Constitution affords. As I conclude, there are additional online resources that you can enjoy. To enjoy the audio court proceedings as well as short audio podcasts about this landmark case, please follow the links in the presentation in this slide. I want to just say it has been a pleasure to be able to bring to you this landmark historic case that impacts my life as a media professional and as an African American woman. If you're interested to know more about me, my name is Miriam Stevens. My website is MsStevensPR.com. I am the brand paramedic. You can contact me, Miriam, for your next campaign. You can email me at miriamsmithstevens@yahoo.com or MsStevensPR@gmail.com or even MsStevensPR@yahoo.com. My website is MsStevensPR.com. I can be located on Facebook at facebook.com/MsStevensPR and on Twitter, twitter.com/MsStevensPR. I am the one that you can contact to integrate new media strategies to launch your ideas. Again, I want to thank you so much for taking the time to review my presentations. Have an awesome rest of your day.